the show now. Let me welcome Justice K.G Balakrishnan, former Chief Justice of India. Vision India Forum is privileged on the first day of the calendar year, English calendar year 2024. Justice K.G Balakrishnan ji has been an avid patron and friend and a well-wisher in an unofficial capacity with us over the last few years, and he has helped us understand the nuances of the subject of his expertise, that is law and order in this country. Somebody who needs no introduction actually, because of the chair, the unprecedented and unparalleled chair that he donned for a few years in the Supreme Court as the Chief Justice of India. Justice K.G Balakrishnan ji agreed, though though he was, not very sure about joining us today, but we convinced him. And today he is going to start the new year with something which has been in the talks over the last few days, especially during the winter session of Parliament, the new criminal procedure laws of this country, which the current Union Minister for Home Affairs, Shri Amit Shah ji, tabled in the Parliament, and both the houses cleared those bills. Now, Criminal Procedure Code, CRPC, the police laws, they are, inextricably linked to the country's and the nation's growth and development story going forward, because no country can progress without a very, very robust law and order situation. Justice K.G Balakrishnan is somebody who knows these entire issues by the back of his hand, and he is somebody who's going to take us through the backdrop of the procedure codes. He's going to take us through the connection between the old and the new ones in brief, and how it is going to be a game changer for the country in the next few years. Coming the next 6 months, these laws will take effect. And then post that, how the institutions, the stakeholders are going to deal with this new laws and law and order, kind of a scenario, and how it is going to impact the common man on the road, the common Indian. So that is how, this entire today's discussion will unfurl. And so I hand it over to Justice K.G Balakrishnan ji. Sir, over to you, the Bharatiya Nyaya Samhita.
Dear friends, this Bharatiya Nyaya Samhita requires a detailed study. This is a short notice. Within short notice, I must say that I could not make a detailed study of the new law. But however, having agreed to make a talk, I will specifically say some of the salient provisions of the new bill. Indian Penal Code has a very solid history. It was drafted long back by very eminent English jurists. Lord Macaulay was the law committee chairman, and it was drafted 1830, but it was kept it was not implemented because Indian law, criminal law, was mostly administered by the local laws. But in 1857, the mutiny occurred. Then British people thought that it is not possible to control the people. That then it was introduced, and it made 1860 Indian Penal Code came into force. It's a beautiful legislation. The very definition of various the criminal acts has been done excellently, and it contained only 511 sections, Indian Penal Code. Now it has been amended, and we have to see how it will, the new law will affect. It has been minimized, the section has been reduced to now the new Bharatiya Nyaya Samhita. There are only 356 sections. And these various 175 sections have been amended. Some sections have been added. Some provisions, sections have been completely repealed. That is to be critically studied. I would request the students to study. They keep the old the penal code and the new book, and you understand the various provisions, what are the changes made. We can only just discuss about some of the various important changes that have been made in the new criminal law. The three, you must understand, the criminal laws, we mean the Criminal Procedure Code, Indian Penal Code, and the Evidence Act. Of course, the Evidence Act will apply to civil action also. But these are the three criminal laws most important. All the three have been, the various amendments have been made. In the Indian Penal Code, some of the important provisions have been, some have been deleted, some of them have been in view of some of the decisions of Supreme Court. For example, 377, unnatural offence has been deleted because the Supreme Court said the unnatural offence decriminalized the unnatural offence. That is, then the 377 has been deleted. But the other provisions have been, depending upon the various, the mob lynching, all those have been added in the Indian Penal Code. The sedition has been made that is amended, and unity, that is the sedition has been amended to include a more comprehensive definition that somebody who is doing anything against the state, affecting the integrity, unity, integrity, or endangering the unity and integrity and sovereignty of the country. That is against that importance has been given. Then terrorism has also been defined in the new code. It is described as any disturb the unity, integrity, and sovereignty, or the public order. That has been, terrorism has been defined. So this is also various provisions. Some of the provisions, the punishment has been increased. Some of the provisions, they are reduced. The defamation, some punishment has been changed. So, some various amendments have been made. That is important. One important is the mob lynching, which is very common nowadays. Some of more than a group of people come and so that is even a capital punishment has been prescribed for the mob lynching. That is also then the sexual exploitation of women and children. That has also been given more importance. If sexual exploitation of women on the pretext of marriage or job promotion and all these is also made punishable under the new code. For another important, it was not in the old penal code, that is community service is also added as a sort of punishment. So somebody who is committing an offense can be asked to clean the public premises or wash all these. It can be it is not a custodial sentence, but nevertheless it will he should do some public service for the offense, because all offenses are against the state, against the public. So he can be asked to do community service. Then all cases are to be investigated within 90 days and should file final report within 90 days. Court can extend, of course, 90 days more. So 180 days. The case which occurred today should be final report, should be filed by the investigating officials within 180 days. Then this should be, it is mature for trial. So that is time limit is prescribed. That is also a provision which to improve the efficiency of our judicial system. So various the marital rape below the 15 was included. if one is the so-called wife is below 15, was considered to be rape, but now it has been considered as 18. It is increased to 18. So that is also a change that is made. Then these 354, the offences, the 509 has been added along with the 354, 350, these all the affecting the dignity of the women. So that is also some amendments have been made in the penal code. This is to be studied carefully. And then only we can we understand the various provisions. Now we can just a cursory look of all these provisions and understand how the common law. But these changes, many of the sections have been removed, reduced number. How it will work, whether it is requires any further amendment or further addition, you have to see. It is only when this is a law put into practice, not just like in the not vanish in the thin air. It is daily. We are got thousands of criminal codes. The criminal codes are every day they are dealing with the criminal laws, the offences, various offences, the police, the prosecutors, the advocates, defense lawyers, all these, the criminal system in this country consists of various groups. It is if one fails, then there is the failure of justice. Investigation is bad, the accused will suffer. Investigation is not properly, or the prosecution case, the witnesses are not giving proper evidence. So all these are very, very important matters, and the new penal code, then it is put into practice, then only we will realize what is the lacuna left there, but is there any amendment is required. You see, Indian Penal Code, which was came into force in 1860, had very, very few amendments. A 498A or some these provisions are then recent after Nirbhaya case, we amended some of the provisions. Failure to record the FIR is made an offence. Failure to the investigation caused injustice to the party made an offence. Then the recording of 164 statement, these directions. Now in the Indian Penal Code, it is specifically stated that the 164 statement of woman shall be recorded by a woman magistrate. That is, I don't know how it is possible. So if it is a case, if the one magistrate is not available, then she has to be sent to a nearby magistrate who is where there is availability of woman magistrate. So that is also important change in that sense. After Nirbhaya case, some amendments have been made, but for you must say for more than 1 century, the Indian Penal Code was like a big, very, very important enactment which guided the control the law and order situation in this country. Now these amendments, we have to look into it. We have to carefully watch the magistrate, and I also feel, being associated with the Indian judiciary for a long time, I feel that there should be regular classes, training courses for the judicial magistrates, first class and civil judge junior division classes on this subject. They should be properly trained and all the nuances of this new law should be properly made them understand and how to implement them. That is more important because they are dealing with the rights of the people. It is to be done very, very carefully. Nobody shall be prejudiced. Nobody shall, a criminal law is something goes wrong. He is to be sent to prison. Something goes wrong. The complainant may not get justice. And nowadays, the people are more and more active. Victims are active. The relatives are active. So, the new code should be carefully studied, and the judges and the lawyers also prosecute. Lawyers, of course, they will try their best to help the clients. But the judicial officers should be given proper training. That is very, very important. All the high courts should pay attention to these, and that too, the Indian Penal Code, not only Indian Penal Code, the Criminal Procedure Code, and also the Evidence Act has been amended. So these three enactments, what are the amendments? What is the implications of this amendment? What changes have been made? They are to be noticed by these magistrates, and they should properly implement these provisions without causing any injustice either to the accused or to the prosecutors or to the general public. Is very important, and I feel that your organization shall continue this sort of discussion and on this subject, not only on Indian Penal Code, but on Criminal Procedure Code, because it controls the whole procedure of the trial of the case. That is also very, very important. And the Evidence Act, of course, that is also to be taken note of. So thank you very much for inviting me to this function. I am sorry that I could not make a detailed study of the enactment and give a full-fledged lecture on the subject.
Sir, we will have a detailed. Sir, we will have a detailed.
On another occasion, we will do it. I provided you give me sufficient time. Sir, I was otherwise.
Sir, as I initially started, it's a courtesy meet today with you to start and kick off the new year under Amrit Kal, and we are, as always, deeply gratified by your, acceptance of our invitation. And I do understand it is absolutely early years and early days for this new legislation to take effect. Sir, a couple of observations. The reduction in the number of sections is fine, but they have tried to make the law more in sync with contemporary issues. That also is understood. But do you not think that the kind of infrastructure and the systems we have in place from a law and order and judiciary perspective, this will the kind of understanding that is needed for the new laws to be in grasp technically and operationally by the authorities at the time of the kind of time that will be required? Don't you think that the lackadaisical and the system, which is full of so many lacunae, infrastructural and so many manpower related lacunae, this entire thing will get further leg space, and the common person will be more disadvantaged because of this sudden, because this is not a GST, it itself, the GST, for example, itself had a huge impact. If I draw a kind of an analogy, the sudden implementation of GST had a huge impact on the business sentiments of this country, of the middle class businessmen especially. Don't you think that this law will have a much bigger impact on the society if implementation is not taken forward in a very careful and systematic manner? And how long will do you think this process will take to have any positive impact on the society? What are your views on that?
The training of judicial officers in many states are not in very good shape. So some of the states have got judicial academies which give the proper training. But in many states, the judicial academies are not there. The training courses are, the Bhopal we have got judicial academy, but it is not a place where all the magistrates can come and attend from all over India. It is only the High Court, the state High Court has to take immediate action to teach these the changes made in the law. That is important. Otherwise, they may commit mistakes, and the lawyers will try to exploit the situation, or somebody, and not lawyers generally, but those who are bent upon creating the exploiting the situation will create problem. So that may not be the all the magistrates may not be able to know and understand this law from the correct perspective.
So
the
from the criminal procedure code perspective, from the police perspective, because police has been
they
a
have
big
to be
question
given
mark.
they have to be given training, and that is very important. So I have suggested that there should be the channel the for starting the educating the judicial officers, a separate channel for the that is required. It is only, I have seen only in the country Brazil has got a separate the electronic media for training. We should also have urgently should have electronic media for giving training to all. It is not possible to call all of them to under one roof and give training. It is not even from the one district officers cannot be given training at one place.
Now, how do you expect the common man to be conversant with some basic issues like 420 that has been changed to some other section? The the death penalty has been changed from 302 to 101. This kind of
Yes,
things.
yes. There will be a little confusion because everybody knows 30 is 302, 30. Now it is 101. What is murder, culpable homicide, murder, everything. Definition 299, 300, 302. All these are all for a lawyer, a criminal law practitioner. They are all the by heart. What is culpable? Now the section has been changed. The position 101, 102, and all this.
Regular day-to-day affairs, regular day-to-day affairs of the common person. For example, you talked about mob lynching. It has been promulgated into a new section, and it has been inculcated in the new Samhita. Now this is a trend which has caught up over the last few years because of social media and politicization of various issues. Now, how do you think the common person, because for them it's a la la land, for them it's a banana republic, any which ways. So now today when this new law has come in, how will that creep into the society's psychology as soon as possible? What do you suggest?
That too, capital punishment is prescribed for the offense. The mob lynching and death of somebody, capital punishment is so it has become a very serious offense, has been newly introduced in the penal code.
So what was the law previously?
It was there was no offense.
Suppose some 10 people lynch a person. What was the law? Because what we knew is that
they were all under unlawful assembly. 124A, there is unlawful assembly. Number of persons, more than 5 persons enter into any criminal activities. They are considered to be unlawful assembly, and they are the common intention of those unlawful assembly is taken and considered. All are the punished. That is the
and less than 5, sir, less than 5.
Less than 5, the offense of unlawful assembly will not come, but they will be individually. They also, if it is more than 5, it's on any criminal intention is that they are considered as unlawful assembly. So that is various definitions are there. So now the mob lynching has been considered separate. So that how it will work out. And capital punishment, the one view is that that punishment itself is to be abolished, and many countries have abolished it. So now we have created one more offense under the. Anyway, it requires a
Are you,
detailed study.
the final question before we end, I mean, are you in sync with or in agreement or consonance with this kind of capital punishment being extended to such offenses?
Because is capital punishment is included to have a deterrent effect on the criminals. So it may have a deterrent effect, one who, but mob lynching and all is just a sudden somebody, you see, actually, I have tried several, dealt with hundreds of cases. It is only one or two persons who is responsible. The rest are simply onlookers, or they'll shout at the two or three, one or two or three persons commit the criminal act. The rest are the just onlookers shouting and encouraging them, or keep silent and watching it. This is the real situation of any guy. You can visualize. You roadside something, somebody comes snatch the chain, then a group of people collect around him, beat him. Then so who is beating? One or two persons. Rest are only just go and see. But when the police is arrested, oh, they are all members of such organization. They are all.
So before we end, sir, could you just speak a couple of lines about the Indian Evidence Act, the 1872 one, I think 1972 one, or and the current one, how changes have been affected, and what would it encompass?
No, I have not studied in detail. We can have it on some other session. Evidence Act.
Okay. We look forward to having the detailed discussion very soon with a few more dignitaries joining you. So thank you so much for giving us this time today on a short notice. And this is something which will really, set the tone for the entire year going forward, especially this being 2024 election year. Thank you so much, sir.
Okay. Thank you.